Word on Wealth with Gary Quackenbush is sponsored by the Word on Wealth Radio Network. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary is a San Diego financial solutions attorney protecting people like you. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future. Now, you're live.
Hey everybody, welcome to Word on Wealth. It's so good to have you along today. We have so many fun things that we're going to talk about here on the Word on Wealth. I want to talk about like successor trustees doing their job, how to be a good successor trustee. I want to talk about whether, what if there's a house going to be sold? What should you do? How much should you spend? But I want to start out talking about the Secure Act and the new changes that came up just very, very recently. Basically, we had this thing called the Secure Act that came up, and it had to do, it dramatically changed the way that inherited retirement accounts are handled and the way regular retirement accounts are handled. It's so exciting, I can barely speak. So what happened is, prior to the Secure Act, if you had a retirement account, like let's say an IRA. So if you had an IRA and there was a requirement that you would take out a certain amount of money every year, that's called a required minimum distribution. So every time there's a law change in something like this, they're always kind of messing with the RMD, the required minimum distribution. Some people don't need the money that's in their retirement account, and they would just rather let it sit and grow because it's tax-free while it grows. If you pull it out, it's taxed. They don't want to take it out. But the government doesn't want you to leave your retirement account just sitting there forever without touching it so that it will go on to your heirs. They'd rather have you pull the money out. So there's a chart that shows how much you need to take out of your retirement account and when you need to start taking out that money. So it depends on the type of fund. It depends whether it's a 401k or an IRA. But basically, if you're continuing to work and contribute to the fund, you don't need to pull money out. There's no RMD. Talk to your financial advisor about that. So if you're retired, whether you need the money or not, there's going to be a required minimum distribution. And you don't have to take it out and spend it. You don't have to take it out and give it to your grandchildren or your children, although you could. But that money needs to come out of the retirement account, the IRA or the 401k. It shows up on your tax return as taxable income. And then you put it just in your investment account. You just slide it from the IRA to your regular investment account, and you paid taxes on that transaction because it's now taxable income to you. So the government has seen it pass through the tax system. Happy day, they get their money. Okay. What the Secure Act did is it changed when you need to take an RMD, and it used to be like 65, then it went to 67, now it's 70 and a half. And then the RMDs now are going up to 73 under the Secure Act 2.0. So most people don't even have to take out, if they're not taking them out now, they won't have to take them out until they're 73 years old. And it's something like 10 or 15 years from now, when the law changes, it's going to make it so that you won't have to take the money out until you're 75. So I think it's in 10 years from now, the RMD, you have to start taking out when you're 75, which is like whatever, big difference. So those aren't the biggest changes. People get excited about it. I mean, some of the biggest changes with this Secure Act, the Secure Act 2.0 that we really like are that you can have, you can have a simple, or, there's these retirement plans you set up as a sole proprietorship, and you can set them up as a Roth type, which means the money is just contributed or put into the retirement account after taxes paid, and it grows tax-free, and it can pull out tax-free, including earnings. So those are Roth and Roth style retirement accounts for a lot of people are terrific because they don't need the deduction of a regular IRA. Instead, they want to go ahead and put that money in after tax and let it grow. And then when they pull it out, there's no tax on the growth, which is fantastic. So the Secure Act did some good things. What it did that kind of stinks is it changed how inherited IRAs are handled. Any money that you get, whether it's a 401k, 403b, or an IRA, if you get it, you inherit it, you now have an inherited IRA. So even the 401k, it turns into an inherited IRA. It's no longer a 401k because the 401k means that you worked for that company and they put the money away and it's 401k style. It's no longer 401k, it's an inherited IRA to you. Okay, so let's say you inherit money. Your dad worked really hard, and for the 40 years that he's working at this company, for the 40 years that he had his 401k, he put away $400,000. You just inherited it. It is now an inherited IRA. All right. There's new rules. We don't look at you and determine the required minimum distribution. So if your dad was taking out required minimum distributions and now you have his $400,000 account, which is your inherited IRA, we're not going to do like we would have with your dad and look at this chart that says, okay, you're 70 years old and you're taking out money. And the chart says you're going to live, that a 70-year-old has to take out 1/30th of the account or 1/25th of the account. Is usually there's a number. So like each year, the number gets smaller. So you end up having to take a greater fraction of that account. The idea is they want to figure out that by the time you die, according to their chart, the IRS has that account. You have drawn it all out to zero and it's all been taxed before you die. Okay. So with the, when you inherit it, they don't look at your age. They don't care about your age. They say when you inherit money through an IRA or a retirement plan, qualified funds, we call it, if it's in qualified funds, from the date of death, which is the date you inherited it, within 10 years, you must pull all that money out of that retirement account. That doesn't mean spend it. That just means take it out. So the rules have been changing. They've been all over the place. We've been talking about it literally for probably a year and a half on what is going on with the Secure Act. Okay. The question has always been, the rule says the inherited IRAs must be liquidated, which means pulled out of the IRA and taxed within 10 years from the date of death. If you didn't pull it out within 10 years, then you're going to get penalized and it's going to be 50% of the amount that you should have pulled out. So that makes a big difference. Dad saved up $400,000. If he were still alive, he would probably be able to draw that out with RMDs over the next 20 or 25 years. You, however, have to get it out in 10 years. So does that mean you take out 1/10 this year, 1/10 the next year? That it's more of a calculation than that, but do you have to take out even amounts through the next 10 years? And the answer has come out to be now, no. The big question was whether you had to take anything out during the first 10 years or whether you could just wait until the end of the year, before the end of the 10th year. And the answer came out now just recently that for the first 2 years of that plan, which is 22 and 21, they are forgiving 20 and 21. They're forgiving anybody that failed to take out an RMD. So if you didn't take any money out of your inherited IRA because you thought you didn't need to, that's fine. You don't have to take it. You don't have had to have taken out any money, and there's no penalty for failure to take out the money. Okay. And this changed 2 weeks ago. So it's all brand new stuff. So it changed just a couple of weeks ago. So if you were facing penalties, if you didn't take out an RMD, if the IRS is going to charge you penalties for not taking out an RMD, those penalties can be waived. And you don't put the RMD back. You just keep it. You already took it out, whatever, that's fine. And then you got to work with your financial advisor and figure out how much money you should be taking. So the rule now is that there are RMDs, required minimum distributions from any inherited IRA. And I'm going to tell you what they are in just a second. So there is a requirement of RMD requirement, and now you must take it. If you don't know the rule, that's too bad. They will charge you a 50% penalty for failure to take out the required minimum distribution. This is Gary Quackenbush here on the Word on Wealth. My number is 855-500-TRUST, 855-500-TRUST. If you have questions on this stuff, you have an IRA, an inherited IRA, let's talk about it. 855-500-TRUST.
You've got questions. We've got answers. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. gqlaw.com. You're saving and investing for the future, and that's good. Have you ever stopped to think, where does my money actually go? This is faith-based investing with Anthony Wright.
Most Christians just don't understand that the money they save for retirement usually helps fund the abortion industry and other liberal anti-family causes. But did you know that with just a few minutes of your time, we can screen and clean your investments at no cost to you? It's absolutely complimentary. Just go to the website right now, download a free copy of my book, Faith-Based Investing. It's free as well. You deserve to know the truth as the investor. Then the choice is yours. You can keep doing what you're doing, or you can line up your investments and life savings with your beliefs. We are fiduciary investment advisors. You can feel good about investing with confidence. So learn more now. Go to BibleSafeInvesting.com or call me at 931-RETIRED. Your free book is waiting for you. Go to BibleSafeInvesting.com and be sure that you listen to Faith-Based Investing this weekend right here on Family Talk.
Gary, how do you and your team help our listeners avoid probate?
Well, first of all, probate is a process that involves attorneys, judges, and sometimes contesting parties. And so we try to avoid probate at pretty much all costs. The way we do that is setting up living trusts, setting up properly documented wills, putting the property like houses, cars, bank accounts in that trust so that it avoids probate. Probate is only necessary if the estate plan isn't set up quite right. So we help them get it set up right. And mainly that's done through a properly created living trust.
Call Gary and the team at GQ Law, 855-500-TRUST, or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free initial consultation. That's gqlaw.com, 855-500-TRUST.
It's the
Phone. Ask for the legal help you need. Call Gary and the team at GQ Law, 855-500-TRUST, or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's gqlaw.com, 855-500-TRUST.
You're live.
Welcome back. We're so happy to have you along. I'm just glad that you're listening to the show because this is stuff, this is the type of work that I do. When people ask what kind of attorney you are, I say, well, I do estate planning, which is wills, trusts, power of attorneys, estate distribution, inheritance distribution, inheritance disputes. We do all that kind of thing. And then we do tax problem solving, debt settlements. So that's, we did the show so we could share this information because I just don't think, my experience is still that people just don't know how to do this stuff, because if you're going to put together your own trust and will, you've probably never done that before. You're planning to die and you're only going to die once. We're all going to die. That's just the way things go. We have, we came down to this earth and we got our little ticket, and someday it's going to get punched and there we go back. So, it's just something that's going to happen to all of us. We all have to face it and deal with it. I was talking to a lady today about putting her estate plan together, and she's really sweet. She's talking about, doing it and trying to make sure that she was taking care of business as much as she could and being responsible. And she said, I used to not really get worried about it, but then I've had, family members pass away in the last year. I've had several. and you just start to face your mortality and realize, age doesn't matter, health doesn't matter. Those are contributing factors, but still, we don't want to leave a mess for, our loved ones, the ones that survive us, the ones that take care of, that get our money, our wealth, that wealth transfer after we die. So that's what we're talking about. All right, a couple of different stories. So one, this is a real story that happened quite a few years ago. It's something that plays out very often. It literally as often as today is an issue that I addressed. And that is when someone passes away and they have a house that's in the trust. So example, in this case, mom and dad passed away. The mom and dad had, they bought the house for like, $50,000. Now it was worth closer to $900,000 because they'd been there for 45 years. And they did, they took care of the house, they took care of the stuff, the landscaping and stuff like that. But as people get older, which happens to most everybody, the attention to detail in the yard and the attention to detail in the house, it just becomes less. It gets to where our vision gets our vision gets less and lower. We have these we can't see, I don't know, we don't notice things as much as we get older because of vision, and because we just, not that we don't care, but there's just other things we're trying to function, like keeping ourselves healthy and alive and all that stuff. So what happens is then things kind of fall into disrepair. All right, so mom and dad have the house, and now the successor trustee, you, for example, are trying to figure out what to do with the house, and you're thinking, gosh, we just want to put it on the market because the siblings, nobody really wants to live in the house because they all have their little world and their jobs and they're doing their thing. And so we want to sell mom and dad's house. Now, there was a situation where the brother decided he really did not want the world parading around in mom and dad's house in the condition that it was. They'd been there for a very, very long time. It just wasn't as clean as it should have been. The carpet was worn out. The furniture was looking pretty ratty because that was okay with them. So what he decided to do on his own as the trustee, he decided he would clean out the house. That's perfect. He decided then he wanted to remodel because it needed to be updated. Mom and dad had been in the house forever, so he decided to remodel. Now his sisters were fuming mad and saying, no, you shouldn't be remodeling. And he said, don't worry about it. Well, he did a bunch of the work on his own. He hired a contractor to do the work with him. And he spent about 1.5 years doing a remodel because he's working with a contractor. The contractor goes to another job because this isn't his highest paying job. And then the contractor comes back and they have supply issues. They have work issues. It's going slower than you think. And anybody that's had anybody work on their home, it never goes to plan. I mean, I just had a remodel where it really did go to plan, but it was like we were on top of every little thing, and it went for a long time. It's not uncommon to have a remodel that goes for 6 or 8 months. Well, in this story, what realistically happened is he did the remodel. He did some himself, trying to do it not on the cheap, but kind of trying to save money for the trust, which is good and noble and all that stuff. But what happened is the market took a dive. This was happening back in 2008. So he spent $80,000 on remodel. And then while he was remodeling, the market was tumbling and he couldn't sell it because the house was being torn apart. So when finally, the house was ready to sell, sold it, and they sold it for over $100,000 less than we have an established value at the time of the death. So if within a reasonable period of time, he had been reasonable about his repairs and had a reasonable amount of time that it was happening and the market was dropping, we would have been okay with that. But the problem is he kept going on and on and on. And it was over 1 year later, the house value had dropped over $100,000. He'd already spent $80,000. Where did he get that money? He got it from the trust account. He got it from the trust account because that's the money he's managing. So he spent the $80,000, it lost value. So what happened? That's $180,000 cost to the trust. How much of that was valid? Well, that's what we had to determine. Was it did it make good sense that he took a year and a half to remodel the house? Did it make sense that he even remodeled the house? Is the market timing is not his fault, but the fact that he delayed for so long, it became his fault. So as a successor trustee, what I'm usually telling people is get a good agent. Like I have some friends of mine that have been real estate agents for a long, long time. And each of the ones that I talk to, I say remodel and sell or sell. And they say spruce it up and sell. Don't remodel the bathroom. Don't put in new countertops. Don't put in new kitchen, cabinets. Don't, put in fancy carpeting, because all that stuff is probably going to be replaced by the family. Whoever buys that house is going to change it out anyway. So it's not necessary to go through this huge, big project and try to reset everything and do remodels and all that. It's just not necessary. It's a waste of time, waste of money. And the risk of trying to get that money back out, the risk of trying to get that money back out is that you may never see that money again. And if you don't ever see that money again, that's a big problem, because if you dump 80,000 into remodel and then the house goes up in value, it increases the value of the house by 80,000. Well, that's a zero. So was that a good plan? Was that a good plan that we spent all that money? No, it's not a good plan. You got to talk to a real estate agent who's ready to move the thing, get it on the market, spend what happens. My friends are telling me you spend $10,000 to $15,000 sometimes in painting, cleaning, super thorough scrubbing, cleaning, maybe put in new carpet if there's threadbare carpet, but you don't do much more than make it so that it looks good, it's presentable, it doesn't look like totally worn down, and that way it makes it more presentable, and the people, they're going to upgrade the carpet and whatever anyway. So anyway, it's just, as a trustee, the other thing is, do you really want over the next year and a half to be working with contractors and trying to figure out what's good and what's not? Now, those of us that have remodeled parts of our home, you're having to make decisions on knobs, doors, wood, electrical outlets, where they're going to be, lighting, where things are going to be positioned, how much it's going to cost. I mean, it goes on and on and on. You have to be there making decisions, because you can't just say, just do the best you can. So do you want to do that as a successor trustee? And I say no. Okay, now helping you be a successor trustee, I'm all about doing that. My number is 855-500-TRUST. I'd be happy to help you out. If you're a successor trustee and you need help, let my firm figure it out. Let us help you out. Let's tell you what you need to do, these requirements and stuff we're going to be talking about a little bit later. Okay, so really, it's a matter of just taking care of business and doing the essentials, getting all the legal requirements, but don't worry about playing contractor, playing kitchen remodeler, whatever. You're not trying to build value of the trust. You're trying to preserve it. You're not trying to make the estate bigger. You're just trying to keep it from falling apart. So the other story that I have regarding that same thing, this is a trustee. What about if the trustee is just hanging on to money, not wanting to distribute the money, just hanging on to it? Mom and dad left some money in an investment account, and then the trustee lets it sit. Well, if the trustee just lets it sit and, it could have done better, in other words, could have talked to a financial advisor, could have done better, then the trustee might be getting in trouble, like if an asset drops. And that happens to the best of us, where you're managing money and the market crashes, and, and it's not your money, it's inherited money. You're not sure where the investment was anyway. You've tried to look into it and you don't get it to cash fast enough. Well, at least you tried. But if you're just sitting on it for a year and a half without doing anything, what my attorney tells me is, he said, if you've got money that you're sitting on, you should put that in something that's earning money that you still have access to, but don't invest it in something wild. You don't want to go and all stocks or something that's way too risky, but you want to be able to get advice and put it in something. And I'm not giving financial advice. I don't do that. That's Anthony Wright. He's on Thursday. So
2 minutes.
Listen up on Thursday. We'll be talking about this stuff. But you could put it in something safe and secure so that the money will grow at some rate, not alarming, not wonderful, but it won't be garbage rates, but at least it will be increasing in value while you're holding the money. See, the trustee's job, you guys, the trustee's job is to be reasonable in what they do. It's not to make money for the trust. It's just to preserve the trust estate. So if preserving the trust estate means that you have something sitting in a money market account, that's okay. If it means you bought a CD and it worked out timing wise, that's okay, depending on the CD, right? But it doesn't mean you should be sticking it in, some Apple stock or some stock in the FANG or something like that. Those are too risky because there's a huge, big risk of loss. And as a successor trustee, you don't have the, you really don't have that opportunity or that power or the authority. You really don't have the right to invest the money unless you get professional counsel. All right. So what we're going to be talking about, the next thing I want to go into a little bit is, what about if the successor trustee has money that's in the account? So you have, let's say you have like a rental property or a family vacation property. And that's what I want to talk to you about is, what do you do if you have 3 beneficiaries and they don't agree on how that property is to be managed or held or taken? There's different options. It sometimes gets a little exciting, but I want to talk about that coming up next. If you want help with any of this stuff, I really would love you to call my office, 855-500-TRUST, and let us help you out, help you be a good trustee. If you have questions as a beneficiary, you're wondering if things are being done properly, don't wait too long. Don't wait till it's too late. Give us a call. Let's figure out if things are being done okay. And I may say, yep, thumbs up, things are good. Or I may say, no, we got to do something to correct this. 855-500-TRUST. Coming up next, we're going to talk about, what about non-pro rata distributions of trust assets here on the Word on Wealth.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to the Word on Wealth with Gary Quackenbush. We are here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com. 855-500-TRUST.
With SRN News, I'm
Outreach, the Word on Wealth with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. gqlaw.com.
All right. As promised, we are going to talk about a couple different things. You're listening to the Word on Wealth, and I'm happy to have you along. It's always good to know that people are wanting to be educated about estate planning. You can pass the word along to those people that need to know, and hopefully you are one of those also. We're talking about a distribution. So this is a family trust that has a cabin, and the cabin is in Mammoth. So the Mammoth cabin is, it's used for skiing, and in the summer they can do hiking and mountain biking and stuff like that. So you have this cabin and there are 3 kids. They're trying to decide how to divvy up the cabin, because it's not the biggest asset, but it's worth, $500,000. So the $500,000 cabin is a big issue, and the kids can't decide, how are they going to do this thing? How do we divide it up? And so 2 of the kids decided they want the cabin. They want to take it as part of their distribution. So you have that 500, you got to divide it by 3. So you're, $170,000 each or whatever. So you establish a value. You can look at hypothetical costs of sale, like what is the cabin actually worth? And if they say, well, it's 500, well, if we sold it though, then you're going to have, costs of sale. There's going to have the closing costs, and maybe there's financing costs, maybe there's transfer fees, maybe there's some extra taxes that are due, whatever. But there's these closing costs, the cost of sale that can be taken into consideration. And what you do, because the kids don't want it just sold and then they share the money, that's the easy way. Instead, you determine a value, and all the beneficiaries can agree on a value. You get an appraisal, you look at it, they can do their own research or whatever, but ideally the beneficiaries will come up with an agreement as to the value. Sometimes that's with the help of your attorney. Sometimes it's with the help of your real estate professional, but we come up with a value, the beneficiaries agree to it. Then on the distribution, you make an agreement that shows that it is not a gift from the one that doesn't want the cabin to the other 2, because then you have the gift tax issue. Not going to be gift taxes, but there's going to be a reporting requirement and stuff. So you want to avoid making it look like a gift, because then it starts to look funky, and we don't want that. What you do is you do an agreement, and it's a beneficiary agreement between the 3 beneficiaries in this case, and they sign an agreement that says, yes, our brother John, our brother John and sister Susie are going to take the cabin, fair market value, agreed upon, whatever, but it's non-pro rata distribution. It's not an even 1/3 split like everything else is, but it's a non-pro rata distribution that we agree to by another agreement. So that goes into the trust accounting, that the cabin went to the 2 beneficiaries instead of all 3. There's another adjustment in the trust that pays the beneficiary that didn't want the cabin. They get money that would be the value equivalent of their 1/3 share. Okay. That's one way to do it. Another way to do it is you can have where you do this pool idea, and that is all the money. Cabin's worth 500, the investment account's worth 500, and there's $500 of cash. You can divide it up and say, fine, one of you take the cabin, one of you take the cash, one of you take the investment account, and divide it up that way. That's another way of doing it. That's still pro rata. The asset itself, each individual asset is not distributed pro rata. So you don't have to declare that it's a non-pro rata distribution. Keep in mind that if it's an investment account, your money that's in the market, money market or stocks or bonds or something like that, if you make these distributions and say, okay, you get the house, you get the cash, you get the investment accounts, what if the investment account shoots up in value and now all of a sudden it's worth 25% more? Well, the cash isn't worth any more, and the cabin may or may not be. So did that mean you gave somebody, one of them got an increasing value asset, or a producing asset, and the other one got didn't get one? That's going to be a problem potentially. So that's why some people like me, we like to make it so that there's everything's in cash. I don't really want to transfer a stock, because my opinion is if you have a stock account or even mutual fund account, is you don't just give it to one kid. You make it so that account gets divided between all of the kids. And the instructions I'm giving to the investment company or the mutual fund company is like, okay, I need 1/3 of this account to go to this person, 1/3 to go to this person, 1/3 to go to this person. If it's stocks and bonds, and there's a bunch of them in the account, either there's 8 or 10 or 12, then you have to go and say exactly how many shares. If they've got 432 shares of Costco, and you're going to divide it 3 ways, the companies that are you're asking to split things up, the investment houses, they want to see the exact percentage or the exact number of shares to like 3 decimal places. So if it's not evenly divisible by 3, you're just going to have, you can have a bunch of numbers to the right of the decimal point, and they usually want you to be 3 or 4 digits accurate that way. So there's different ways of doing it. And, sometimes with being a successor trustee, the job is really kind of thankless because people don't really appreciate how much work you do. It's just like, well, it's just a third, just take it and divide it in a third. And it's not that easy. But what I will say is once you do get things figured out, and once you spend the time, and especially if you have a professional that knows what they're doing, helping out, it makes the world of difference because you know what's what's legal, what's legitimate, what you have to do and what you don't have to do. As a successor trustee, I've seen a lot of clients that are trying their best to be a good successor trustee, and everything is fine until there's a lawsuit. Everything's fine, everybody's happy until they're not. And when they're not, that's when the gloves come off, and that's when you get fights. And there are plenty of attorneys out there, unfortunately, that like to stir the pot, that like to light the fire under people so that they will fight with each other, and then they can support the litigation. And it is so expensive to fight about it. My preference is, if we're trying to somehow save personal relationships between siblings, I'm going to do that. If there's a way to preserve it by making some type of a compromise, or we try to make a compromise that we call a win-win, because we want it so that both parties are equally satisfied with the results, and they didn't have to spend a small fortune or a large fortune on attorney's fees and getting stuff done. So I think a lot of these things, you have to take them into consideration, because it's money you've never had. So I say get a professional. Remember, with the cabin, you can do a non-pro rata distribution agreement is one way to do it. If you had a rental property, you're probably not going to want to, let's say it's you and your sister, and you decided you're going to own the rental property together, and then your other sister, she doesn't want anything to do with it. Non-pro rata distribution. But the two that own that property together now, they are legally partners for all intents and purposes. Under California law, if 2 unmarried individuals, or meaning not married to each other persons, if they are in a common enterprise where they're going to earn any money, it's a commercial enterprise, that is a partnership. So you automatically have a partnership with your sibling on this rental property. And are you going to own it as a corporation? Are you going to own it as a limited liability company, or as a straight up partnership? So those things have to be decided. Now, I'm the big proponent of limited liability company. If it's a rental property that you've inherited, take it from the trust, put it into a limited liability company, and then have the beneficiaries, instead of getting 1/3 of the rental, they get 1/3 of the membership interests, 1/3 of the ownership of that LLC, because that way you're protected. Your home is protected. If there's some liability, there's a slip and fall or an injury or lawsuit or an accident or something on that rental, it doesn't come back to bite you. Of course, the LLC needs to be insured. You need to make sure you meet all the legal requirements and all the local requirements to make sure that everything's good. So if it's in good standing, the LLC can protect you. Also with an LLC on a rental, so I'm assuming then in this example, that you decided to inherit the property, you take it as a rental, and now you're owning the LLC. You don't own the rental, you own the LLC that owns the rental. And that's where it gets you that new veil to drop and keep the liability fenced back from you personally. This is the kind of stuff we do all the time. 855-500-TRUST. If you've got questions, you have a question you want to get answered, 855-500-TRUST. Let me know. We can work with you on that. As far as the you set up your own estate plan, if you don't have one, that's the kind of stuff that we do every day. We love working with our clients on that. I want to finish up talking about a couple of different things. There's like with trust, this is kind of my day to kind of resolve or dispel some of these myths. Like, what is a sprinkling trust? What is staged trust? We're going to talk about that coming up next right here on The Word on Wealth.
You've got questions. We've got answers. This is The Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQlaw.com.
So Gary, we've talked a long time about estate administration. So what is that and why is it important?
Estate administration is the distribution part of estate planning. So when someone passes away and they leave money to beneficiaries, the property has to be administered. So it's like taking it from the decedent to the survivor. That's called the estate administration process. So usually you're going to have a successor trustee that's named in the trust. They'll have no idea what they're doing because they've never done it before. So then they call on GQ Law and we walk them step by step on how to be a successful and good successor trustee. We also do the required notifications. We notify the Department of Health Services and all the legal requirements so that they can have the estate administration done properly. We help successor trustees be successful.
Call or click to request your free consultation. GQlaw.com. 855-500-TRUST. GQlaw.com.
Here's an easy way to advance the gospel and bless missionaries worldwide today. If you own a vehicle you no longer need, donate it to ChristiansWhoCare.org. You've heard about Christians Who Care Ministries car donation programs since 2005 here on KPRZ KCBQ. The charity was born right here in San Diego East County. Your donation of virtually any vehicle, car, truck, or van, running or not, is 100% tax deductible. It's easy to donate. Pastor Paul and his team at Christians Who Care Ministries are ready to accept your donation or answer any questions. Call toll-free at 888-488-5808 or use their simple online donation form at ChristiansWhoCare.org. They'll call within 24 hours to arrange your free vehicle pickup. You'll receive your tax-deductible receipt. ChristiansWhoCare.org is an IRS-approved 501c3 nonprofit ministry. Call 888-488-5808 to learn more.
Hi, this is Ken Anderson.
You're not alone. Ask for the legal help you need. Call Gary and the team at GQ Law, 855-500-TRUST, or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's GQlaw.com, 855-500.
Welcome. This is so good to have you. I want to share with you a couple things that I have. I just feel like we need to talk about this stuff. But we have a situation where there's a lot of terminology that we use as estate planning attorneys. I mean, we all use a lot of terminology, and it's like it's not unique to our industry. It's not as bad as like skateboarders and their bro talk, but it's pretty bad. So what a lot of trust attorneys do, and this is, I have to confess to some of this, is that we use terms, and instead of explaining things, we go, oh yeah, that's a spendthrift trust. That's a sprinkling trust. That's a pool trust. That's a staged trust. So there's all these different terms that we have for people. That's a anti-disinheritance trust. That's a retirement protection trust. There's all these different things. Well, I was talking to an estate a planning attorney. He's been doing estate planning for like 43 years. The guy's got 10 years on me. So he knows what he's talking about. So I was talking to him a little bit about some of these designations, and what the thing that you get is we were kind of laughing because I was reviewing a trust with him, and and he said, okay, because I was reviewing this, and he said, so what about the amendment provision? Who has the authority to amend? Just look that up real quick. So I start scanning through this trust, and it's 40, 50, 60 pages long. And it's like, it doesn't say right up front who can amend the trust, who can revoke the trust. It goes on and on and on with all this garbage that nobody understands and nobody reads, and it's totally unnecessary because you don't have $80 million in your trust. And it just makes it so that these documents some of these trusts that people put together are impossible. There's this I don't know. They just keep adding and adding and adding and adding and adding and adding to these documents that are so phenomenally complicated. So my attorney friend was saying, gosh, I can't stand these trusts that are like 40 pages long. And I said, well, I can't stand the ones that are 80 and 150 pages long. And we're just kind of lamenting because we have to read through those things, and it's just all unnecessary. All right. So he said, find the trust on the amendment. Who can amend? I read through it. I go, okay. Both of the trustors can amend it. All right. What happens when one of them dies? Okay. Now I have to read even further, blah, 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 blah. What if one of the trustors dies? Okay. You can still amend it and revoke it. But it took me like 10 minutes to get to that point in the trust document. And in my trust, it's like right up front. It's pretty obvious who can amend it. It says so. And so I know whether it's irrevocable on the first death or whether it's irrevocable on the second death. So I can tell that. Of course, I know the trust because I drafted it, but we were just kind of laughing at how long some trusts are. And so you hear people say, oh, that's a sprinkling trust. It's like, what the heck does that mean? Sprinkling trust. Well, the idea of a sprinkling trust, that's different than a pooled trust. The sprinkling trust, the idea is that money sprinkles out. It doesn't just get gushing. It's funny. It doesn't go gushing out to the beneficiaries. It sprinkles. So the trustee has the authority to sprinkle the money out rather than to gush it out. The trustee doesn't have to just calculate all the assets and say, here, beneficiary, here's your money. They can sprinkle it out for this reason and that reason and for this thing, and sprinkle and sprinkle, sprinkle. So, that's one way to call it. I tend to use more English, and I say it has staged distributions, and the stages at which the money is paid out to the beneficiaries happens at certain ages. So I'll say it's staged based on age. So you can, they get money at age 25, they get more money at age 30, they get the rest of the money at age 35. That's staged. It's also called sprinkling. Sometimes it can be part of a pooled trust. So pooled means that all the money is kept in one trust or pool, and that the monies going to the different beneficiaries are from this pool. So if you have staging distributions that says, let's just do an easy one, that beneficiaries get their money at age 25. Okay, so you pass away, one beneficiary is 25, one is 20, and the other is 15. What happens? Well, the money is pooled, and you have 1/3 of that money, because there's 3 beneficiaries, 1/3 of that money, there's one beneficiary that's 25, they just get their share. So 1/3 of it goes to the 25-year-old beneficiaries, done. Okay, then the other 2 beneficiaries now have the remaining, and that remaining fund. So 5 years later, when the 20-year-old turns 25, they're going to get how much? They're going to get half of what's left. Well, that's probably going to be, potentially, it's going to be more than what the original 25-year-old got, because now it's had 5 years to grow. Okay, then when the third kid turns 25, it's going to have been in there for 10 years. So it's going to be even bigger. So some people don't like the pooled idea where there's this fund that grows. What I typically do is we do a trust that have subtrust. So you're going to account for each child's money separately. So you're going to have 1/3, 1/3, 1/3 at the beginning, and then each child's going to be accounted for separately in a subtrust. Now, the subtrust can actually live together. Okay. Cats and dogs living together. Oh my gosh. but you can have the funds living together. They're just accounted for separately. So each one of those accounts gets accounted for separately. If there's a draw out of the account, it comes out of that child's third, not the entire pool. So there's different ways of doing it. I like to be a little independent with kids so that it's not like the youngest kid. There's, it's all spent out and there's nothing left of the youngest kid for the youngest kid. That's the fear of like a true pooled trust, that the older kids can draw all the money out if they have it for necessities and all that kind of thing. I like to split it out so that it's more staged and it's accounted for separately so that the kids don't get burned by an older sibling over hogging the money. So sprinkling trust, pooled trust, stage distribution, spendthrift trust, all these different terminologies. I mean, it's everything. And then you get into acronyms like CRT, which they call it CRT, which is a charitable remainder trust, and you have a CLT, charitable lead trust. Then you have grantor retained unit trust. There's all these different funky trusts that have to do with charities and charitable contributions. We used to do a lot of them when the amount you could transfer after you die was low, like $1 million. Now it's $12 million. So don't worry, if you have less than $12 million, you can distribute all of your money to your kids and there's no inheritance tax, no wealth transfer tax. You're not going to have an issue. But once you get above that, we got to be really special with all these irrevocable life insurance trusts and grantor retained unit trusts and these different fancy trusts to try to keep the taxation down to a minimum. And if we can, totally eliminate it. After 2025, a couple years from now, the laws are going to change a lot. So if you have money right now, if your estate, you're single and your estate is worth over like $5 or $6 million, you should not be in a regular trust. You should be in some type of an AB trust, some type of a charitable remainder trust or something, because in 2026, January 2026, your money is not going to be, you're not going to be able to transfer as much money and you'll be over the limit. Because right now the limit is 12. By the time we get there, it's going to drop to 6. So if you're at 6 already, or 7, we need to start talking about what other type of trust you might need to get your money to beneficiaries without spending a fortune in taxes. And they are expensive. Inheritance taxes are 40%. Okay. And they're not going to go down at all. The government needs a lot more money, so they're not going to go down. So those are things you might want to look at if your estate is fairly large, or if it's huge and you're right close to the exemption. We should probably look at it and make sure that it's going to be okay. Some people they just want to reduce the size of their trust so they don't have so much to give to their kids because they don't want it taxed. So they'll do charitable things so that they give their money away to charity now and for charitable purposes now. So they start to get some deductions, a reduction of estate, the size of your inheritance and stuff. There's lots of ways to do that. But I want to kind of get into some of the terminology a little bit. I thought that was kind of fun. If you want help with this or you want me to do your estate plan, 855-500-TRUST. If you want help being a good trustee and doing the work that the trustee needs to do, because it's hard work. It really is. It's a lot of, you take on the role of another person who's passed away. Usually it's a loved one. And every time you work on it, it's like, I got to, I'm thinking of that person again. It brings up a lot of memories, and that's a good thing, but it also can be really stressful. And so I think it's a good idea to get help. If you want our help, I'm super happy to do it. 855-500-TRUST. A couple more things that are available to you guys. We've put together a really good website called gqlaw.com. If you forget that, just go to my radio show website, wordonwealth.com. So when you get to the website, there's free books. There's one called Living Trust Basics. It tells you the basics of living trust, wills, power of attorneys, healthcare power of attorneys, living trust. It compares and contrasts, what is a living trust and what are the different types. So that's called Living Trust Basics. It's a free ebook on my website, gqlaw.com. Gary Quackenbush, that's the gqlaw.com. Free book, Living Trust Basics. If you also want to find out about limited liability companies and corporations, we talked about them a lot. If you want to know the difference between a living trust, a limited liability company and a corporation, partnerships, LLCs, that's all in the book called Accidentally Self-Employed. If you want to know about getting rid of taxes in bankruptcy, there's a book called Bankruptcy Basics. There's also some other free stuff on there, but go to my website, gqlaw.com. You can listen to our podcast, look at our blogs, all that kind of stuff. Free information. Feel free to go there and download your free book of Living Trust Basics. or put in a friend's name and email address and they'll get it. gqlaw.com, gqlaw.com. Coming up tomorrow, we have got, oh, my good friend talking about mortgages, the real estate market. That's coming up tomorrow here on the Word on Wealth. You guys have a great rest of your afternoon. Bye, everybody. Talk to you tomorrow here on the Word on Wealth.
Tell a friend about the Word on Wealth, featured since 1995 with financial solutions attorney Gary Quackenbush, an expert in estate planning, wills and trusts, and tax problem solving. Gary is past president of the California Society of Tax Consultants. Reach out to us. The Word on Wealth team of financial experts is here to answer your questions and help you preserve your family's financial future. The information you hear on the Word on Wealth is for general information purposes only. This program discusses general financial and legal topics. Seek legal advice from a competent lawyer for your individual